Good morning, everybody. Thank you for being here and thank you for watching. We are super excited to have you today. This is probably one of the ones I've been looking forward to the most. Not only is it a good group today, but we're actually going to get some major fundamentals on attorney fee structures. That's probably one of the number one things that attorneys ask me about, not only to help them with their clients, but also to make sure that they're taking care of themselves. And attorney fee structures are something that are not that difficult to do, but I think that there's just a lack of understanding of how they work. So for those of you who don't know who I am, I'm Traci Kass. I am a settlement planner, a financial advisor, author of What You Can Expect When Expecting a Settlement, which is free to you for your clients. This book was done so that it can make your life a little bit easier. Also, the attorney reference guide. This is to cross the T's, dot the I's, make sure that you're protected when you're working with your clients. And you're in a mediation and you're like, now what did Traci say again? Here you go. That's right. So it's a kind of a pocket guide for a reason. So we're working with that, and if you need any free copies of that, you're welcome to have it. So just getting started today, we'll be waiting for Rob to jump on the call here, or this webinar in just a few minutes, but I want to get started with the guests that I'm super happy and love to death. So Geraldine Lee is with the office of Geraldine Lee, and she is that female entrepreneur attorney, just go, go, go get them. I couldn't, if I said, what does a strong female professional look like? There's a good picture of Geraldine. She is one of has been awarded named one of the top female attorneys in Southern California. She's been one of the top 100 in Southern California. She's the past president of OCTLA, and extraordinaire across just that person that everybody loves. Geraldine walks in a room, everybody's excited to see her. She's one of the best mothers, friends, wives that I've ever met. Welcome, Geraldine.
I gotta have to live up to all those words. My gosh.
No pressure.
Yeah, no pressure. Gotta be like mom of the year now.
No pressure at all. And then I'm switching gears to, again, an amazing person who I love working with for many, many years. Court Purdy is with the offices of Paoli and Purdy, and love his partner just as much. I have to say that, Bill. You're just as awesome. And they do a lot of environmental law, PI cases, catastrophic type of cases. And throughout the day, you're going to learn a little deeper as to when do you want to annuitize, when does a structure work, how does it work. And I have to say that I'm super stoked and wish I could have been there last week, and as Court was crowned one of the top gun attorneys for the Orange County trial lawyers, and I'm super excited for that. Yay, Court! Congratulations!
Thank you so much.
Yeah, fantastic. And perfect timing. As I was just moving over to Mr. Rob Wood, I feel incredibly honored, privileged, blessed, and incredibly appreciative, Rob, for you being on this. Rob is he's listed upon one of the best top tax attorneys in America. So I'm literally not kidding. If there's any tax issues, consequences, or questions in the settlement planning arena, he has experience in corporate partnership, individual tax matters, working with some of the preeminent tax attorneys in the United States. He also works with mergers and acquisitions. Rob's tax planning is very, very broad based. It includes opinion letters, audits, appeals, rulings, many different things, and he's just renowned. I have to full disclosure here today. Rob is so good that I paid him to give me an opinion that didn't work. So I actually had a really good idea, and I really thought that this was going to work, and it was related to attorney fee structures. So that's why I can validate Rob, not only for what he does, but he honestly doesn't say yes to everybody. And I was one of those that I think I had to drown my sorrows that day when I got his opinion that it wasn't what I wanted it to say. But that just gives credibility to the fact that Rob is pretty amazing. He knows attorney fee structures. He is an attorney that represents a lot of the different options that are out there, or understanding what the different options out there. But the main goal today was to go back to some of the fundamentals. And Rob is the guy who has been around and understood this arena for a very, very long time. So I thought I would hand it over to Rob. Welcome and thank you. I really appreciate you being here.
Thank you, and I apologize to everybody for being late. I will tell you, I'm having a few technical difficulties. Anyway, sorry about that, and I hope that I'm not disconnected if that happens, which it may. I hope all of you will pick it up. And I'm sorry, Tracy, I didn't have time to figure out where the slides are. So is that something that you have, or?
I can do a share screen. I will bring this.
No one needs to see my face, that's for sure.
There you go.
Okay, super.
Can you see it?
Yes, I can. Thank you very much.
Sure, just tell me when you're ready to go to the next slides here.
Okay, are you going to control them then? That's okay, great. So let's I guess start with this, and everyone maybe go back to the first slide.
Yes.
So my phone number and my email address are there. Email is easier than phone sometimes, but either way, if you want to contact me to ask a question or something, please email me or phone me, and I'll do my best to try to help. So next slide, thanks. So attorneys' structured legal fees have been around for a long time, since Childs, which was a tax case in the 90s. Surprisingly, it's still kind of the only game in town. It's the only real solid authority that says legal fee structures work. For a long time, the IRS made sort of grumbling noises about this. And I kept thinking maybe the rest of the 90s and early 2000s that the IRS was going to try to push back somewhere or somehow. It never happened, and now routinely, it started maybe 2005, 2010, somewhere in there. The IRS cites Childs a lot in private letter rulings, so it's quite legitimate. Plaintiffs' lawyers are unique. Contingent fee lawyers are unique to be able to do this. Lots of other people would like to, but it doesn't mean you have to do it, but it is a rare opportunity in the tax law to take advantage of. Next slide, thanks. So what is it all about? Constructive receipt, everybody knows a little bit about this. I think it's a dangerous topic. It's kind of a weird topic for lawyers to talk about, because, I mean, you all know, I think, that if you are on the eve of signing a settlement agreement that's going to net you a big fee, you may or may not, as the lawyer, be signing the settlement agreement, but certainly your client will. And when the client signs, if you're entitled to 40%, let's say, you have a right to get that 40%. It doesn't mean that you have the money in your pocket, but it means the defendant has to do it within X number of days. Typically a settlement agreement will say. So that's a key event. You never want to have the client sign the settlement agreement if you want to structure fees, unless the settlement agreement says that you're structuring fees and puts the mechanics in. So be wary of constructive receipt. If you have money sitting in your trust account, even though you haven't dispersed it, you have the money, the client is treated as having the money. These are sort of the concepts, and there's an article linked at the bottom there. I don't know if these will work if you click on them, but if you go to my website, there's a search window, and you can type in any term like constructive receipt, and you'll pull up articles, and you can download them.
And I will make sure that at the end of this, that everybody's watching will be able to have your link as well. Okay,
super. So next slide. So what are the mechanics? I think you all know this. So defendant pays somebody else. Defendant doesn't pay. So you can have and I guess I'm thinking more about clients now than lawyers. I should have said earlier that structured legal fees come out of structured settlements. So the genesis of them was in the early 1980s when structured settlements for plaintiffs took off. And then lawyers predictably also wanted to structure and get payments over time. There's no requirement, of course, that you have a third party. You could say for the client or the lawyer or both, the defendant's going to pay in 10 equal installments. Of course, nobody wants to trust defendants, neither plaintiffs nor lawyers, but you could do that. So the idea here is you're paying a third party, so the defendant's out of the picture, and the lawyer is going to get the stream of payments. So the sort of where the rubber meets the road, the hard part and the sort of strange part is the mechanics of it and how exactly it's done, so that, because if it's not done in the right way for the lawyer or the client, it's considered receipt for tax purposes. So you might say, for example, I don't want one of these fancy structures. I want to know somebody that when the smoke clears after the case is over, I'm going to be owning an annuity that's going to pay me for the rest of my life, or I'm going to own this trust that's going to pay me. And that generally means you're taxed on it. So that's not what you want. Okay, next slide.
In constructive receipt, and this slide and what you just said is probably one of my the hardest hurdles to get over, is that you have to understand that it does have to be connected to the settlement agreement, because often I get that call, well, we've already signed the release or the money's already in our trust account. So this is definitely something you want to think about, in advance.
Yeah, and I would, thanks, Tracy. And I would say, I mean, I get those calls too. And I mean, for anybody who's in that position, I mean, it's nice to have the money. And I mean, there are, I guess I think of them as kind of Hail Mary passes. There are some things you can try. I don't think it's productive to sort of go through them. It's kind of a last resort. But I mean, I have to say, in a few circumstances, I've done them, but you don't want to be in that position. So you don't, I think I say this later in the slides, you don't want to try to do one of these yourself without, I guess, people involved who've done it before. The life insurance companies, if you're doing annuities, I mean, the documents I still find, pretty arcane, archaic. They're highly formal. It's sort of a certain way that these things are done. Mm-hmm. One, I guess, good thing or bad thing, depending on your preference or how you look at it, is you've got lots of choices. And for a client or a lawyer, mm-hmm. I think sometimes too many choices means you don't make a decision. Yeah. At least for me. So you want to have adequate time to think about what you want, and you really can set it up any way that you want, as long as you kind of lock it in before the documents are signed. Right. So, next slide. By the way, all of you, Court, Geraldine, Tracy, jump in and interrupt me anytime you like.
Well, yeah, I would just say that the constructive receipt, I can't tell you how many times I've asked Tracy to define it for me one more time, because of how the settlement will sneak up on you. And if you haven't thought it through beforehand, a lot of times it's too late and you've already signed the settlement agreement. So I agree, that's one of the most pivotal concepts of this entire topic.
Yeah, and it's not really intuitive either. I mean, I think I guess the way I think about constructive receipt is sort of a paycheck at the end of the year. It's the kind of, your employer hands you a bonus check and says, you did a good job this year, or it's not as good as last year, or whatever they say. But you have this check, and of course that's income. But if you say, oh no, don't give it to me, I don't want it until January. I mean, that's sort of the concept of constructive receipt. You have a right to it now, you're taxed on it now. But in the case of lawyers and settlement agreements, I mean, you're right, Court. It comes up a lot. And people end up with money sitting in their trust account. And I mean, I've had tax cases for lawyers who get a big settlement on December 27. And what is it? Is it December income, or can we push it to January? To some extent, it depends. But the normal answer you'd expect from the IRS is that's December income. Doesn't matter if you didn't distribute it until January. So it seems to me that's a good lesson to think. I mean, it's already late in the year now, November, late in the year, start thinking about that. If you have in a settlement, I saw one the other day, settlement agreement that said the defendant's going to pay all this, millions of dollars within 60 days or something. But right now, if you see that, you don't know when it's going to come. I mean, you want it to come soon. But on the other hand, do you want it in December or do you want it in January? Think about it. And if you want it a certain place, you should specify.
One of the things that I always do too is make sure that, even with that said, is when we do start an annuity payment stream into just the next taxable year, like this year, if I was able to do something today, I actually start the payments January 15th, not even close. I never start the payments January 1st, because there's always a potential confusion of having that check cut and getting deposited. So we always start payments January 15th, just to kind of give it a little bit of breathing room as well.
Yeah, it's surprising. I mean, these points seem kind of, seem like everyone would think of them, but it's surprising in the heat of the moment. Sometimes, and you're anxious to get paid, and sometimes you don't know, and it really can be, it is upsetting to get something that and sometimes you can't put the milk back in the bottle. By the way, I've had people, if the settlement agreement says, this isn't constructive receipt. If you before you sign the settlement agreement say, I don't want it for 5 years, and the settlement agreement says we're going to give it to you in 5 years, that's fine. It's perfectly fine. You don't have constructive receipt. You're taxed in 5 years. But if you sign it saying they're going to pay you within 60 days, and then you call them up and say, well, can't we amend that to say, pay me in 5 years? I've done that, but I always warn people, you've got the current right. We've got to have a good sort of reason why we're amending it, apart from we don't want the money for 5 years. So is there some enforceability issue or something else we're changing in the settlement agreement?
That's a really great point, Rob, because I see that often. There are peers out there that do structured settlements that are like, yeah, it's no big deal. We'll just unwind it and we'll change it. And I've obviously unwound and changed things, but I always do let them know that there is a live floating agreement out there already. It isn't just because some structured settlement people will say, no problem, I'll fix it. It really is a problem, and it could be a potential large problem. So let's try to get ahead of it so that we are not signing releases until we have the proper language, because even though we destroy it, it is still out there. And so it's really important to get ahead of it and not sign your documents until you're clear what your options are.
Yeah, no, I agree. So this issue, structure individually as a law firm. So the law firm is Smith & Jones, has a fee agreement for a 40% contingent fee. The case is winding down. The settlement agreement is going to be signed. Smith & Jones is going to get a big check. Smith & Jones decides we want only half of the money. We want to structure the other half. Does Smith & Jones structure, which is the law firm entitled to the fee, or can Smith or Jones or both of them structure? This is another one I've always found surprising. The answer is it's sort of anything goes. However, and my experience is it can be really good if you're the management of the law firm. Some of the big tort law firms do this, to say, let's structure as a firm. The firm gets the money, and then we're going to dole it out to people, and we can have a lot of control over them that way. If people take clients, we can kill off their payments. It's used kind of as a management control device. But the vast majority of people in that circumstance want to structure individually. So I mean, it's this article, I think I did a couple around that time, deal with the kind of little agreements that you should put together, because of course it can be viewed as an assignment of income from the law firm to the lawyer. So it's just important to pay attention.
So Rob,
Yeah.
I have a question.
Sure.
So if you are an associate working for Smith & Jones and you know that you're going to be paid off of that case, would you be able to structure any of those fees that you get paid from that case, like a bonus?
Traci will remember this issue because she
This
just
was my
alluded to
very
it.
expensive issue. No, you actually cannot.
Yeah, it's I mean, it's surprisingly complicated. If you had and this is one of these things where, one of the rare circumstances where I say, you know, gosh, maybe you should think about independent contractor rather than employee. If it were an independent contractor in your example, the example that Traci had or Geraldine has, it works fine. If it's an employee, it's super complicated, and the short answer is no. I mean, I wouldn't say, I think if you're willing to spend a lot of money and do things that are, I mean, it's kind of a deferred comp. There are all sorts of non-discrimination rules that come into play. It's just really complicated. So it's not a simple fee structure if the person's an employee.
And I'll share what I was trying to do is that I had a law firm who had the attorney was an employee, but also had their own corporation as well. The law firm then, when the attorney would bring in a case on their own, that they brought the case in, instead of paying a bonus on the case, they were actually paying a referral fee to the attorney's corporate account, their separate account. So they were not paying, they had a corporation and it was on the referral fee. So my question was, can I structure that particular referral fee because they're an independent contractor or they have their own separate corporation? But the answer came back as no, because there's a conflict with them being an employee. The IRS was not going to probably approve that.
Right. So next slide, please. So I think we've covered this. I think we've covered this one. Next one. So structure with annuities. Back in the child's days, that was the only game in town in the 90s. And it's still perfectly fine. Life insurance annuities, many life insurance companies offer them. It's very similar to the product that they offer for structured settlements for the plaintiffs. And as I hope you all know, although structured settlements started with tax-free payments, so somebody's injured in a bad accident, physical injuries, the way structures work in that context is the payments to the client, each payment is tax-free for the rest of their life or however long the payments go. In contrast, if it's a taxable case, meaning it's employment discrimination or something like that, but it's not tax-free, then it's all about tax deferral. And it's true that you get taxed when you receive those payments if you're a plaintiff, but each payment when you get it is taxable. So that latter one, those didn't start until, I don't know, maybe around the mid 2005 or something, I think. Maybe might have been earlier. There was a ruling issued. The IRS approved them in 2008, as I remember. So, and it's more and more common now to have taxable structures. Think of lawyers' fees as sort of similar to that. Each payment when you get it is taxable. And they were originally done with life insurance annuities. Now, this article, without annuities, there are a number of providers of structured legal fees that have different setups, and you get a better rate of return, more investment choice than annuities. Traci, you want to say anything about that?
Yeah, that over the last few years, that's been a really big incline, just because some of the kickback was the rates were too low, or they're just too restrictive, and so many attorneys have been able to use some products such as Fee Structure Plus or some enhanced attorney fee structure, and those are using market-based annuities. So you still have to follow the fixed and determinable payment stream, when you're going to start the payments, when you're going to end the payments. And usually it's a percentage or a fraction that's going to be coming out at that particular time. So we're still adhering to the rules, if you will. And however, we're able to discuss working on investment accounts. Generally, hopefully somebody's working with me, but you can actually work with your own advisor as well. But those are been fantastic. And for the attorney who's very, very comfortable, I have attorneys that are in energy and a lot of the things that are high risk. And then I have attorneys that will even do a bond portfolio. But overall, the return has been much, much larger. And I think a lot of people just don't know that there's other options out there than the traditional fixed structured settlement. On that note, really quick before we get off of that, is with that, again, planning in advance is super important, because certain defendants, they, as most of you probably listening, know that defendants will have an approved list. And so if we can't get around that approved list, it may not be an option on every single case yet. We're working on that, but it's important to be pre-planning in advance, sometimes your year in advance, that you know which case. Everybody who works with me will know that I'll always say who's paying, who's writing the check, is there an insurance carrier? That way we're getting ahead of some of those rules and restrictions right up front to know what our options are.
Great. Next slide, please. Let's go to the next one. So I guess these are obvious points. Why do you structure? It's asset protection, regularize income if you have high peaks and low valleys in your contingent fee income. So I guess some of the comments Traci just made, I think are important. And I think if I focus, apart from the sort of issues that Cora was mentioning, which is constructive receipt comes up all the time. That's really true. I think the other one that I see all the time now is people that hear what Traci just said. Oh, investment portfolios and a bond portfolio and all this. And so I don't need all of these sort of stupid structured settlement people out there. All I need to do is get the legal fee. Instead of being paid to my law firm, Smith & Jones, I'm going to send it to my, trustee stockbroker, and then he's going to keep it for me and invest it and so on. Why doesn't that work? Because the stockbroker is your agent. It's not set up properly. And I've seen this happen. And it is, and by the way, what do you do if you find that it's already happened? It's not an easy question to answer. But it's clearly receipt by the lawyer. And so it has to be done in a certain way. And it has to be set up so that it's truly hands off, which frankly makes some of the investment decisions tougher. The way some of the providers do it now is to say, you can pick what you want on the way in, and then and you can designate who this the manager is, and you can make permissive requests a couple of times a year, but that's it. You have no right. If you hate IBM now and you want all the IBM stock sold, you cannot say that. You can say, I hate IBM and I sure would hope that you will listen to me. And I think to some extent everyone's going to listen to you, but you cannot have a legal right to change it. So there's a lot of stuff like that, I think, that happens. Traci, do you want to comment?
No, that happens all the time. I have, with everybody I've ever worked with, what you said is pretty much the advisor will listen and understand. So at the beginning of that, there is an advisory statement that is done up front. There's a risk tolerance that is done up front. So just like with any investment client that I would work with, is we're going through the formalities of really understanding, what the goals, time frames are, risk tolerance. You're putting the portfolio together just like you would with anything else. So with proper communication and such, it really has never been a problem. And the people who want to be in the IBMs, they know where they want to go and they know where the risk is. And so that conversation is out there. So for most, you can feel very, very comfortable, but Rob's 100% right. That's the control. And that's why, working with somebody that you trust is super important. Rob, while it's on my mind and I don't forget it, often I get well, I didn't used to have to do it this way, or I've done structured settlements in the past. I've been doing this for 16 years. You've been doing it a hair longer than me. Have you ever seen the ability to just do it without, obviously separate from when you've had to fix things, but in a traditional settlement, there really isn't a way to get around it without being overly creative, right? You have to have some sort of language somewhere, because often I'll say I need to either do an addendum or include language in the release, and they're like, I've never had to do that before. Another broker that I worked with before didn't require that. Does that?
Yeah, no, you're right. It happens to me a lot too. And it's, and people, I've had clients who, get very upset, and to some extent they have to decide who they're going to listen to. And, but yeah, no, I get it too.
Okay.
Let's go on. I want to start racing through some of these. So next slide, please. Oh, timing. Oh, sorry. Go back to timing. Yeah, so I guess this is obvious. We already said this, if the settlement agreement is signed, it's too late. So next slide. So QSFs, qualified settlement funds, that's a bigger topic than legal fee structures. Everyone, I guess, probably listening uses qualified settlement funds.
We probably need to do a seminar on it by itself, because it's such an amazing tool if used properly.
Yeah, no, it is. And I always worry and occasionally see some bad abuses. My fear is that qualified settlement funds, I had an occasion recently to talk to some people at the IRS on something, and I couldn't believe it. There were 9 IRS lawyers on the phone. So I can just tell you from that experience, the IRS cares about these things. I think they like qualified settlement funds, but I also think that you don't want to be the person pushing the envelope. It's an intermediary step. So if you need to sign the settlement agreement, you want to get rid of the defendant. Neither you as the lawyer nor the client know if you want to structure or how you want to structure. Sending the money in the settlement agreement to a QSF and then structuring from there can work fine. So it's a good thing to think about in that sense.
Exactly. It feels like an escrow account. For those of you who haven't heard of a QSF, it's like an escrow account. It's probably the easiest way to understand it. But again, needs to be done in advance and communicated in advance, because there are certain carriers that will give you some pushback and such too. So again, planning in advance. Can't say that enough.
Does the language for the QSF need to be within
the release? Yes.
Yeah, the settlement agreement needs to say we're paying the money to the Smith & Jones trust account, or in which case Smith & Jones and the client have receipt, or it needs to say we're sending the money to New York Life Insurance Company or something for a structure that's being implemented in the settlement agreement, or it needs to say it's going to the XYZ qualified settlement fund.
Okay.
Yeah, so there are a bunch of QSF resources on my website, but more time, I think we said that. Loans, this really isn't our topic today, but increasingly you'll see providers that will structure fees. So you're due $1 million fee. You don't want the money, don't need the money. You want to have it, grow on a tax deferred basis. So you set up a structure of some sort. Let's assume the structure works fine, but you also really need the money. You just don't want to pay tax on it. It's not illegal to borrow the money, but I would just say structured legal fees on their own are, assuming you do it right, I think kind of plain vanilla now. The doing it right is the hard part. to make it plain vanilla. If you're going to do a loan, be careful, because there is a risk that the structured fee and the loan could be integrated by the IRS, and that it could be collapsed and say, this isn't a fee structure at all. All you did was send the money over here and then you borrowed it all back. And so I think it's a danger. This article talks a little bit about that.
Yeah, and I've set them up before, and it has to be, I go the conservative route. There's companies out there that are pretty aggressive.
Yep.
And I will tell an attorney right up front that if they want to do something that I am not even recommending, they have to sign a hold harmless, because there's a lot of risk to certain ones, but it can be done. Again, over and over and over. You're going to hear today that it's about doing it right. There is a right way to do it, but the right way is not in a rushed way. So having conversations in advance can't be stressed enough.
Yeah, I would also say, and this is, well, some people, maybe some of the participants today, think about this as kind of a standard practice. So if you're not so much thinking about a career case, but rather, I'm now age X, and for every case I have now, I'm going to take 10% and structure it. That's also a really, I don't know, it seems to me a smart thing to do. It's kind of like saying I'm going to always stick some under my mattress.
Yeah.
So some people do that. Let's see, do's and don'ts. This one at the top. I don't know if anyone still says this anymore, but it used to be. Okay, I didn't know that. So it used to be the case. I guess I view it kind of as an old sort of canard that you can only structure if the client does. That is not true. Traci, you can say that is not true, correct?
It is not true. Not true.
Yeah, okay. So we've said all this. Oh, don't invent your own, the last bullet there. I think because of some of the things Traci said, an investment account and bonds and so on, I think this is a big danger now. It's a big danger because all of you as successful plaintiffs lawyers think you know a lot, and you do. You know a lot more than I do, and have skills that I don't have. However, I think the more successful people are, the more they think they can do it themselves. And every one of these things that I've seen where people have done it themselves has been a mess. And it may be that the IRS hasn't discovered the mess yet, but it's one of those things where you don't want to be in the room when the bomb goes off. So I would just say be careful. Next slide. When I stuck these slides together, this article from just August, this actually isn't about structured legal fees, but you might find it funny. It's on my website. It's about litigation funding that a lawyer did, himself, as opposed to with commercial documents and commercial litigation funding providers. And it was a disaster. So I could think it's a good example of smart lawyers to do stuff that they're not. It's sort of like if I tried to handle my own lawsuit or something, I would fail. And this lawyer in this tax case failed. I think, let me see if that's it. Oh, opinions, tax opinions, Traci mentioned. Tax opinions, there's a few articles here about what you get with an opinion, why you may want one, how an opinion is different from a private letter ruling. It's never a bad idea to do them, to do opinions. I do a lot of them, and these articles explain why. Next slide.
Rob comes in a lot on some elder abuse type of cases can be tricky. Some of the cases of employment cases, some of the non-physical injury cases are probably some of the ones that I see the most that I will give Rob's name to, just because there's something a little more complicated. And so whenever somebody wants some additional comfort, this is where you can go for sure.
Yeah, actually, thanks. On opinions, I mean, I was thinking of opinions on legal fee structures, which I've certainly done plenty of, but Traci's right. I write more in legal features, I read a lot more opinions that are to plaintiffs in all kinds of cases. I mean, patent cases and real estate disputes and sex harassment cases, employment cases, sort of all sorts of, or elder abuse, whatever it is. When somebody is receiving money, oftentimes, most of the time, they don't know what to do, and they may not think about it until 1099s arrive in January. So keep it in mind. I'm going to shut up. I talked longer than I intended, and I'm happy to listen for questions.
No, this is amazing information. I really wanted to, I know my title for the few of you that said that, I know I was a little risky out there, but I was trying to get your attention. And so one of the next big things that kind of comes up, and I thought I'd let Court kind of talk on it, is when do you do your fees? When do I call you, Traci? When and how? So I thought Court we've worked together for a very long time, and Court has had the ability to look at both fixed and market-based and some other things. So Court, do you want to give them an idea of how and when?
Sure, my pleasure. Thank you, Traci. And before I start, thank you, Traci, for hosting this. I think it's really important. You are the best. That's why I've worked with you.
Maybe a little louder, closer.
Yeah, you're the best, and that's why I've been working with you for so long. You're the one who has all the answers to the questions that I routinely ask. So, in learning about fixed annuities and how you can use them as an investment tool for an attorney, I was actually pretty shocked that the IRS actually had something for contingency fee attorneys that actually allowed them to save for potential retirement. And so I first kind of learned about these things when doing petitions for minors comp. When I'm doing my structured settlements for my minor clients, I started looking at that and going, gosh, I wonder if there's anything that we could do with that. And slowly but surely, I learned, in fact, that there was. So we started to institute the concept of fixed annuities. But the first thing we had to do is to figure out how much money can we put away and still have sufficient funds to run the law firm and to pay for our kids to go to college and do all the other things that lawyers need to do. And so the first thing that we did was to sit down with our CPA, with our office manager, have a really strong budget analysis to be able to lay out, what are our needs, and then looking at the pipeline of cases and when we think they're going to resolve, and do our best to try and figure out the range in which we believe that our fee will be. So then we can gauge, how much we think we can put away in a certain year with respect to the fixed annuities. And so one of the things that I was amazed at was that not only are insurance companies more than happy to help you do this, and governmental entities have their own, administrator who works directly with Traci, but that you can structure a portion of your fee. So I think the first time I did it, to dip my toe in, we had like $100,000 fee. And out of that, my partner and I just took 25 apiece and put it into an annuity to see what it looked like.
Yeah.
And after that, we're kind of off and running, because not only is it easy once you decide that you can do it, because Traci does a lot of the work, you just need to decide how you want it structured and when you want it to come out based on your age. And then after that, there is a ton of paperwork. Oh my gosh, this is an industry in and of itself. Do not try to do this on your own. She's a professional. Just nod your head, read the documents, sign where appropriate, and let them do the work, because they work with all the best insurance companies that are all insured, and you feel very secure in the fact that at a later date at 65, I will be getting these payments. And I've done something for myself and my family that is really hard to do in any profession, but for ours, which is specific to plaintiffs' attorneys, it's one of the best tools that I know of.
That's great. That's great. When so you guys, so number one, you used your accountant CPA to kind of figure out what your budget is. Obviously, it changes when you have case costs that are kind of coming, and so I'm assuming that you left a contingency plan in that budget for case costs. And looking at the cases that are coming up. So you did that first. You had that kind of conversation with your partner to figure out what you needed. And then you guys have your defined benefit.
Correct. So it kind of morphed from there. I saw the fixed annuity situation, and then I learned that there's even further tools that you can use to defer income. And so that's a defined benefit plan, which I think works really well with law firms of less than 20 employees. It works great with older lawyers and younger staff because you can implement a profit sharing plan, which allows the attorneys to actually put more into the defined benefit. You have somebody who's managing it, either Traci or someone else who's managing it. And essentially what you can do is you kind of sign up for a 3-year plan where you say, okay, we're in for at least 3 years. You can do longer, but 3 years is the minimum, I think. And you give them an estimate as to how much you think you can contribute to the defined benefit each year. And the beauty of it is that if you, for some reason, don't have the amount of money that you need for that particular year, you can freeze the account for a period of time. You can make contributions the following year, all the way up to about April, I think.
April 15th.
April 15th. You can overfund your defined benefit if you have a particularly good year, which then rolls over to the next year. And so it is an incredibly fluid and friendly way to be able to put the money away into a deferred package, which usually goes along with a 401k and a Roth you can contribute to as well. So if you have a fixed annuities and then you have the defined benefit with the 401k and the Roth, just a really more balanced way to be able to invest for retirement. And depending on your timing, it can really grow. And it's been a terrific tool for us, and one that I think I just finished the 2nd year of 3, and hopefully I'll be able to continue on with it. There is a maximum that you can hit at some point. We're not there yet, but there is a maximum that you can hit. But in the meantime, all of your employees are benefiting from it as well. So it's also a morale booster because they meet with the gentleman or the people who are managing it. They understand where their money's going. They can contribute, and we match. And so it's all in all, it's a really good plan.
Well, and I love that because when people are just starting out, they're nervous. One of two things: either A, they'll do that work, because it is paperwork, I have to say, right? I mean, there's a little bit of paperwork, but once you get it set up, you're good to go. But some of the concern is, I'm not sure that I can keep it for 3 or 5 years. The IRS obviously wants it longer. And so that's where we'll use a short term, just a 5-year attorney fee structure. And I guess this is a good point to say, you can do structures technically as low as $10,000. Usually 2025 is where you're getting started. And as Court said, he started with 25 up to 8 figures, obviously. So they range. So I don't feel that just because, even if you're a younger attorney and you're just starting out, you start out young and start it going soon. But if you get to the point that you're ready to do a defined benefit or deferred comp plan with your office, you can take a good fee that came in, structure it over 5 years. That 5-year payment pays into the firm. The firm then can feel comfortable that they are fulfilling the obligation of the profit sharing deferred comp plan. So you've taken the pressure off of the firm that what if I can't fund it? What if I can't fund it? So sometimes the annuity will come first, and then the deferred comp plan. And then other cases where it's a sizable, significant fee, then we'll do it the opposite way. So we can do both. And so now, Court, that you've got it up and going, we've been doing a lot more of the fee structure plus. So that's more personal for you, right?
Right, because fixed annuities are wonderful, but the interest rates aren't always tremendous. I think I did the math, and at 65 to 85, my wife thinks I'm going to live to 85, so we had to do it to 85. So 65 to 85, I took the money that we invested in it and I calculated the return. It was actually a really, really good rate of return. So, but the fee structure plus actually allows you to defer your income just like a regular annuity, but put it into an investment portfolio, into the market, whether, moderate, aggressive, whatever you want to do. And so you're actually getting the benefit of the market. Stocks, bonds, equities, whatever you need to do, that pays out at 65 again. So you're not guaranteed of the return, but it's a good supplement to a fixed return. So you've got ones that are fixed, you know exactly what that's going to be. Now you're investing another, 10, 15, 20 years more so into the market where you think overall you're going to gain at least 8%. And then you've got that payout structure there. So it kind of adds a little bit of, I wouldn't say too much risk depending on how you invest it, but it's just another tool that you can use along with the defined benefit plan and the 401k. And to get it all set up, if you've ever done minors compromise cases, you know the paperwork that goes into setting up an annuity for a minor. It's just like that. All the qualified assignment stuff, it's just that same paperwork, but then you don't have to go to the courthouse and get yelled at by the judge for not doing everything perfectly. So that's the difference. You know, you don't have a judge overseeing it. It's just the IRS, and Traci takes care of all that. So all those tools that we talked about right there, I didn't realize were available to me until the last 7 years or so. And since then, I've tried to take advantage of them as much as I possibly can. And it's been a godsend. And I feel a lot more at peace with the ability to maybe be able to, you know, not work as hard as I get older. And I would, you know, for young lawyers, it's invaluable. If you just take a little chunk of each settlement, you'll be so far ahead of the game. You won't be able to conceive of it when you're my age.
Like that latte factor for attorneys, just a little bit, just a little bit on each case, and it'll pay off in the end. Thank you. That's
absolutely
good. So Geraldine, we've worked together for 12 years or so, and I think when the minute I met you, you were like, "What? Who? Oh, I'm in," and you jumped in. It didn't take long. It didn't take years to warm up to this. Once you got the concept, you were like, let's do it. And this makes sense. One of the things that's been really fun working with you is you've really had a different goals, different cases mean different things. Versus I would say it typically takes 3 settlements. At 3 settlements, most attorneys figure out their stride as to where they want to put it. Is it short term for the fulfillment of the law firm and overhead? Is it long-term for supplemental? And then they make adjustments. It usually takes 3. But when working with you, you've had so many structures anyway, but you're very unique with the ones that you do. Can you explain a little bit?
Yeah, sure. I mean, I loved listening to Rob tell us about the legal implications, because what I'm doing is okay. I am still within the law. And one of the things that he said, which was really important for everyone who considers doing something like this, is planning. You've got to come up with a plan. So my very first structure, so what I want to talk about is like the practical side of it. And so my very first structure was with Traci. When I first met her, she was talking about, she gave a seminar, lunch and learn. And I said, you know, I could do that because my kids, I think at the time were only 6 and 8.
Yeah, 5 and 7 or
they were super little. And, you know, my concern has always been, how am I going to pay for their college? Because you know, they are going to college, even though they're telling me now they're not going to college, they're going to go to college. And so my very first structure was speaking to you, Traci, about how do I save this money for when they go to college? And, you know, you were talking about, you know, a small amount. My very first structure, I think, was $20,000 in my fees. And I said, are you sure it's not too little? I mean, I just feel like it's insignificant. And you said, no, because you're concerned about kids going to college, let's have that $20,000 not pay anything until they get to college. And excuse me, the very first payment just came this year. And my math was off by 1 year. My daughter starts college next year. But from, 10, 12 years ago, my money has almost, I wouldn't say double, a little bit less than that. But because I didn't need it for so long, the annuity companies were able to give me a better rate of return. So this also comes with planning, because you have to understand that once you decide to structure, okay, you can't take that money out. I'm talking to the attorneys that are new to structuring, whether you're a new attorney, you're an attorney that's just leaving a firm and you started on your own, you know, you have to come up with a plan. And that plan is, when do I want those payments to begin? What do I want to do with that money? So some of the other structures that I have gone to either retirement, I am not a public employee. My husband is, so thank goodness he's got his pension. But all the people that we're talking to now are not public employees. We don't have a pension. So structuring is like our pension. It's like our retirement, and we can guarantee that money, at a certain time coming in either monthly or annually. I also recently did a structure with Traci where I had it pay my current mortgage. So Traci asked me, well, how much is your mortgage? And I said, well, I'm trying to get into this house, so it's going to be, blank, a certain amount of money. And she says, great. Well, let's take this money that you're going to get from this structure and let's start paying your mortgage. So every month I get a check, and I don't have to worry about whether, the Jones case is settling or the Smith case is settling. I know that I'm not going to get kicked out of my house for another year and a half. I need to start adding on to that one. But at least I know that my mortgage is going to be paid. And then also, I haven't done this yet, but I know that a lot of other attorneys are doing this. They calculate the monthly expense that they need to run their office. And, if it's just the rent, the phones, whatever, they have that annuity pay them that basic monthly expense. And you can do that as well in your personal life. And all of these tips on planning can also apply to your clients. So if you're talking to your clients and they don't know what to do and they're going to get $5 million and they're just going to have a rager in Vegas, you should talk to them and say, you might want to think about your retirement. Maybe you want to think about paying your overhead or your mortgage or your car payments and your insurance. So that same kind of planning applies. TK, can you bring up the spreadsheet? So I'm going to show you a sample spreadsheet that Traci puts together. Okay. If you
see?
blow it up. Yeah. Can you just blow it up a little bit?
Let's see if I can. A little bigger. Did you get it?
Yes. Okay, perfect. Okay. So this clearly is not mine because I don't have that many structures and I don't have that much money in these structures. But as an example, so I have a very similar spreadsheet. So if you go to number 1 and it says claimant, and that is a reference for you for the case that you settled. So this could be the Jones case, and you've decided to structure $125,000. And you tell Traci what it is that you want at every year, of your life, or how you want those payments to come in. And so what she will do is put together this spreadsheet. And so that from age 55 to age 65, these are the amounts you're going to get. So why is that important? Because if I'm planning to retire at 55, I'm going to go across the 55 age row, and I'm going to look and see if I'm going to be able to retire. And from this spreadsheet, it doesn't look like I'm going to be able to retire at 55 because that's really not going to be enough money. So you can use this spreadsheet to also plan for your own retirement. And you can see at each year how much your annuities are going to pay you. So TK, if you can run your cursor over the total per year, the column that says, total per year, and that's the pink column. So you can see that starting in, at age 60, you might be able to live off of 176,000, depending on your lifestyle and how many times you go to Vegas. But you can then see how much more you might want to add on to each of those years. So I have been able to use structures really to plan out my life and how I'm going to be able to afford certain things. And I know it's a tax deferral. So eventually when I'm paid on these annuities, I will, excuse me, hold on one second. Sorry about that. I have allergies. And so you will be able to see at, how much you're going to be paid and what else you need to help you out. And then one of the things that I know Rob mentioned, but I really want to emphasize this, is constructive receipt. And I don't know if you all know what that means. You can't receive that money. You can't have it go in your trust account. You can't have it, sitting there where you can access it. So make sure, if you are considering structuring your fees and your client is considering structuring his or her fees, that you contact Traci, or if you use somebody else, but I really highly recommend that you use Traci because she knows all about, dealing with clients and plaintiffs, and she knows all the different options that there are out there. But start the planning before you're sitting at a mediation and the mediator has a release under your nose and says, sign this now. Okay, this is the language that should be in a release, or if your mediator has a mediator's proposal, or this is a mediator's stipulation, and then the language in the release agreement will come later. This language must be in that mediator stipulation or the release. And, again, like Rob said, don't try to reinvent this. Just ask Traci, give me the language, and then you copy it word for word, because then that allows you and your client to structure.
And this is really just a placeholder. There's, Rob probably has 3 paragraphs of legal language that he would put in it, but this is just, I know that when you're in the heat of the moment, it just gets to the point you're like, oh, what do I need to do? The main goal, whatever the language is that you do use, the main goal is that the defendant is 100% aware that they're going to be doing a structured settlement. Because I can say over and over again, I will call them and they're like, we didn't agree to that. We didn't say that we were going to do that. And so it's super important that if the plaintiff or the plaintiff attorney can do a structured settlement, because then we win every time that there's been particular language, either in the mediation stipulation, or even if you're just doing an email or a letter correspondence that says we will accept it, contingent to the ability to do a structured settlement. But don't just stop there. They actually have to execute the necessary documents, which is called an assignment document that is needed to be done. That's assigning the obligation from the defendant to the annuity company. We have to have certain documents. So it's super important, even if it isn't the exact word for word, and I often get a text, hey, I'm in a mediation, I need that language. And by the way, it's in the book. It's in the attorney reference book too. But the goal is to make sure that they know, because if they don't know, you have a problem later. I'm going to go back to the spreadsheet just real quick, because Geraldine, that was really good. This kind of goes along with just saying, you can see here that it took three annuities before we got to the point that what is your goal? And then what had happened is the attorney at first wanted to start covering a little bit of overhead for the first couple of years, and then started feeling more and more comfortable with what was coming in. And this is just a sample. I have ones that just have 25, 50, and I have ones that have $1 million, $2 million, $3 million. So we have spreadsheets that are all over, from small amounts to large amounts. However, this particular attorney had gotten to the point that they knew that at 59 and a half, they can assess their retirement plan that they've done for work, just their 401ks and other retirement IRAs and stuff like that. So, but they didn't want to touch it quite yet. So this took it until the required minimum withdrawals. It's now been extended to 72. However, it was only until 70 and a half you had to take money out of your IRAs. So what we did is we pushed the IRAs to not start until 70 and a half, and that's why this attorney had made an adjustment. One of the best plans that I put together, I started working with an attorney when he was 42 years old. His first annuity was 1.1 million. He actually created a lifetime income for that actually covered all of his insurances. So that was his long-term care insurance, his health insurance, life insurance. All of his premiums were made at the beginning of the year. So that check covered for the rest of his life all of the premiums. His second settlement was 700,000, and we created a pocket. Every other case after that was 25,000, 50,000, 200,000, 300,000 here and there. However, his goal was $400,000. He was 42. His goal was between 53 and 83, $400,000 a year. So the spreadsheet becomes very addictive because, and I do, because I like it. Because right, G, when you
Yeah.
see yours, you're like, I got to fill this. I got to fill
Right.
it. It's competitive. I got to fill my spreadsheet. So just starting somewhere and getting it started is what the most important thing is. So I know we're kind of wrapping up a little bit. Geraldine, any other last comments that you have?
No, but you know, if I can emphasize anything, it really is to start planning. And it is very painful and hard to take $20,000 off of your attorney's fees and set it aside, right? Everyone knows something that they can do with it. You're going to go buy that new car. You're going to pay off this loan. You're going to do something. But really, as much as you can, plan for your future and plan for some of these things that you might want to do later on. And then tax deferral. You know, what if you've already settled a ton of cases and you just don't need the income? Then a structure is perfect for you and for your attorney's fees. So
Thank you.
for having me.
Kurt, last comments?
The one thing I don't want to do is give most of it to the IRS. So I want to put it away into a spot where, you know, later on, maybe my tax basis is less. And so it's just a great way. And it truly is something that you can do to give yourself peace of mind. And it hurts in the beginning, but once it's done, you forget about it until you look at your spreadsheet. You're like, okay, I'm doing okay. And so I would once again trust Traci's judgment on these things. She can put together a plan for you that is really helpful and beneficial.
Thank you. Thank you. Love working with you guys. Rob, I can't tell you how much I appreciate you. I feel incredibly lucky to have somebody like you on this panel, and your time is priceless. So
Thank you, Rob.
any last comments?
No, nothing for me. I'm good. Anytime.
And everybody, I will make sure that everybody's contact information is out there too. Rob is the guy, and I have to tell you, I'm not sure that I've ever called you, Rob, as busy as you are, that you haven't answered your phone. Like always, you're always answering your phone.
It's a bad habit.
Yeah, you'll feel better with somebody on your side. You want Rob Wood on your side. So thank you for this panel. I appreciate everybody's time, and I'll get materials out to all the people watching. And thank you so much for joining.
Yeah, thank you for having
Thanks,
us.
everyone.
Everybody.
Have a great day.
Bye.
You too.
Thanks.